everybody. Welcome, wherever you are in the world, to this webinar. I hope you're all well. My name is Paul Gibbons, and welcome to our webinar on disputes and international arbitration. I am one of the founding directors of Hewitt Decipher Partnership, with 25 years of experience in construction, representing employers, contractors, subcontractors, and acting as independent experts. Today, we have over 375 registered for this event, hence the slight delay in starting this webinar, so waiting for people to join us. The webinar today will consist of a panel discussion, which I will moderate, and we would welcome any questions that you may have. So please put these in the chat, and if we have time at the end, I will try and facilitate those questions accordingly. The panel session will be about 45 minutes in duration, and then, as I say, we'll have some questions at the end. So I'm very pleased to be joined today with Tom Francis. Tom is a discipline lead of project controls and delay of Hewitt Decipher Partnership, and he's also director of Decipher Consulting. Tom is a planner, an expert witness specialising in delay analysis. I'm also pleased to be joined with Rupa Lakha. She is a partner at international law firm Russell Speechlys and head of the firm's India desk. Rupa is a highly experienced construction disputes lawyer and has ranked in the Legal 500 Next Generation Lawyers for construction for both contentious and non-contentious. I'm also pleased to be joined today with Mitesh Vekaria. Mitesh is the managing director of Vascroft Contractors Ltd and past winner of Times of India and the ICICI Bank Global Entrepreneur of the Year Award, Europe region. Mitesh has a background in chartered surveying and over 17 years experience across corporate real estate, new build, refurbishment and fit out projects. I'm also pleased to be joined with Brynmor Thomas QC. David is a barrister and international arbitrator with 39 Essex Chambers, and he's the joint editor of Global Arbitration Review Guide to Construction Arbitration. David is a globally recognized specialist in the conduct of complex, high-value international commercial litigation arbitration. And David is also referenced in Who's Who Legal as a thought leader in arbitration. And we should also have on the panel today Andy Hewitt. Andy is the managing director of HDP with over 40 years experience in the construction sector. And he's also author of several books on claims on contract administration. However, Andy has a few internet issues this morning, and so unfortunately, he will not be joining us on this panel session today, but hopefully Andy's in the audience and he may ask a few questions of us, who knows. Okay, so just setting the scene, from my experience, construction contracts around the world regularly end up in a dispute if the contract has not been administered properly. But dispute resolution can be very costly, and moreover, to refer a dispute may go against the culture of the parties of the contract where the contract has been undertaken. And there are many pitfalls along the way which need to be considered. So on the panel discussion today, our aim is to discuss with the panelists their experiences of dispute resolution and how to ensure success from different perspectives, looking through the eyes of a contractor, a solicitor, a barrister advocate, and indeed a consultant stroke expert witness. And we're going to hopefully get their views on all those matters. So without further ado, I'll kick off with the questions. So turning to you first, Rupa, if you don't mind. So working on international projects can raise unique challenges ranging from cultural, legal, and project-specific issues. So from your perspective, when embarking on a project, what should parties do to set the project up to minimize the risks of disputes? And can the contract or the systems be set up to help this? So Rupa, if you'd like to just open with that, please.
Sure, thank you, Paul, and thank you everyone for joining. I mean, as a disputes lawyer, you've hit the nail on the head in terms of minimizing the risk of disputes and trying to avoid them or even manage them better is completely dependent on what you put in at the outset. Getting the infrastructure for the project right at the outset is absolutely crucial. And there's a tendency to want to get on with the job, to get people on the ground, maybe have a letter of intent in place and just see what happens, because one feels that that might be the most efficient way to get the job done. But actually, we would really say that the amount of investment at the outset is what will dictate the future success of the project. So there are certain things that one should have on their checklist that one should consider, even at the bid stage. For example, what is the appropriate procurement model that's being used for this project? Is it going to be the one that ensures maximum delivery for the project in the long term? What level of resource has been provided for? What's been priced for? Again, it's not, there should be an indication if the lowest bid is dramatically different to the next one alongside that. That should be ringing an alarm bell, rather than encouraging people to just go simply for the lowest price. Is the program realistic? Tom, I'm sure you're smiling when it comes to thinking about this, but actually if the program is unrealistic from the outset, that really needs to be considered. If not, pay heed to those warning signs. Consider, this is critical, what risk is being placed where, because that's going to dictate whether or not there is a dispute. A client of mine, main contractor, was asked for the refurbishment of an existing tunnel and for the creation of a new tunnel. The new tunnel was fine. It was many hundreds of millions of pounds. The refurbishment of the existing tunnel was 10 million, 16 million, something like that. And they weren't allowed to inspect it before signing up. But what they did, they had, I think, 2 hours on 4 occasions to walk through the tunnel. They then signed up to taking the risk for the entire structure for 60 years thereafter. Now we're about 8 years on, and you can imagine what's happened. The new tunnel is absolutely fine. The existing tunnel is riddled with problems, and we're looking at a wholesale replacement. So really think, where is the risk being placed, and what is it asking me to take on for the duration of the project life? And you've touched on it, Paul. How can we set the contract up to deal with those? It's about getting all those factors to come through. Look at the interface between different parties in terms of the legal aspect. Where is the legal risk being placed? But where's the interface with the technical input to ensure, again, that all parties are on the same page with what they want the project to deliver and how long they want to deliver it for? Bearing all of those in mind at the outset will be absolutely essential to ensuring that any disputes are kept to a minimum.
Thanks, Rupa. That's very informative. And I think from what I see as well, it's, as you say there, it's that transfer of risk, and it's making sure that the person that's best able to manage that risk owns that risk. And what we see regularly, how the risk potentially is given to the wrong person, and that can just lead to no end of issues, and obviously disputes will flow from that, unfortunately. So Mitesh, just moving on to the contractor's view, we know that change on most construction projects, if not all, is inevitable. And some of that change will inevitably lead to delay and disruption. But what, in your view, through the eyes of the contractor, do you think can be done to minimise the risks people face when approaching a dispute or engaging with their advisors?
So thank you, Paul, for that. Essentially, I'm going to repeat a bit of what Rupa said, is that at the pre-contract stage, if you can spend some time and energy possibly using a pre-contract services agreement to try and de-risk as much of the project as you can, to try and work out what the unknowns are at that stage, and then make sure that the right party is carrying the risk to take that matter forward. It's very easy for clients to say we want a one-stop shop, and we want to put everything onto the contractor, but that's not necessarily the right place for all things. So spending time up front pre-contract is always a good way to try and avoid potential disputes from the very beginning. But in the commercial world, there's not always that much time available, so those steps are missed. But if you have that time, I would say that's good tip to sort of take on board. But to ensure, to avoid the disputes that are exhausted, make sure there's no possibility of heading down a litigation route. I think it's being engaged with all the key stakeholders throughout the life cycle of the project. So in particular, the principals are quite detached from the everyday runnings of the project. So if you're able to engage at a principal level and approach perhaps CEOs or key stakeholders without an audience, more so, that is always a good way to try and avoid disputes, because they will probably be detached enough to look at it from a commercial point of view, and everyone knows going into disputes is the wrong energy for a project. It's a waste of everyone's time and resources. So sometimes if you're able to get high enough up the tree, you're able to just say, look, let's just park this and we'll figure it out, and you can avoid the whole shooting match that is to follow if that step is missed.
Sure, thanks, Mitesh. And you pick up on a point there about the pre-contract part of it, and it's a very valid point. Do you think that's driven by the employers, by not allowing sufficient pre-contract information and also pre-contract program time, which is also coupled with the advisors giving them perhaps inaccurate advice and late design information? Do you think that there could be some improvements there to allow that pre-contract stage to happen? Because you're quite right, that is where most contracts fall down, by not dotting the I's and crossing the T's, and the bids aren't properly qualified, or there's things that have been missed, and then once the project's fully up to speed, people are just forgetting about what they should have done and what they should have contracted to price on, and they just fall into this pitfall, this black hole. So do you think there should be some education of the employers or the advisory team, or is it just what we have and we have to just suck it up?
No, definitely, Paul. I think we've experienced a number of our clients that see the benefit of the pre-contract services agreement, and they spend the time up front. Normally you get 4 to 6 weeks to tender a project, and they think they've put all the correct information into the tender pack, and then out comes a price, and then they go away and letter of intent, and you're into contract and you get on with the job. But as I said earlier, you miss a key step where they've done that in isolation of the contractor for the period of time that they've had the project on their side of the camp. If they could spend time with us as the contracting parties to try and work through workshops, you could de-risk so much of the project. But to answer your question, yes, the employers need to have that in their project Gantt chart, time allocated, pre-contract, where they can actually work through the whole project, educate the contractor of everything they know. They may be living and breathing that project for a year or so prior to going to tender, so they know a lot more about it. And if they can share those characteristics or attributes of the project with the party that's contracted to build it out, I think that's only a benefit for the project as a whole.
So having that early contractor engagement on a predetermined fee, let's say, after the employer's gone through some due diligence around some selective tendering, I think that's obviously a good option to move forward, and it would potentially help in the process, as you've already suggested there, which is great. So just sticking with you, Mitesh, just if you don't mind, in terms of when you're on a construction project, from looking at it from your perspective, and then I'll move on to Rupa, back to you in terms of your viewpoint. What do you see as the warning signs that a dispute might be on the horizon? So Mitesh, from your perspective, looking at it through the lens of the contractor, please.
I think the early warning signs are when the professionals get entrenched in their positions because they're advising their clients, wearing their professional hats, and quite rightly they're advising correctly as far as they're concerned. But if you've got the professional view, and then you've got to come to some sort of middle ground to try and compromise a win-win, really, because if everyone goes away in their entrenched positions, that the only other alternative is to enter into dispute resolution processes. And so the early warning signs for us is, we can see valuations may be tinkered with, and they cause cash flow problems. And essentially, when it's commercially hit, these things pile up into problems that need resolving. So the early warning signs are professionals, the viewpoints that they take, and advise their clients accordingly. That's a very big telltale.
Absolutely. Thanks for that, Mitesh. And Rupa, anything to add to that from your perspective, please?
Yeah, I think definitely it's the way in which the contract starts to be used, because we talked about having the right contract in place and administering it properly. And a lot of the contracts provide for notices to be given at various stages, notice in the case of a delay or stuff. And you can tell that there are problems starting to bubble when all of a sudden notices are fired off, or the odd letter comes in that's random, and it's using the contract in a defensive way. That structure and that mechanism, using notices, should be used as a mechanism of saying, look, there's a potential issue on a project. We're putting that flare out so we can all come together and work through the issue and get that engagement, as Mitesh has talked about. But actually what we see happening more and more is that actually as soon as COVID happens, or there's an issue in terms of an instruction that the contractor's unhappy about, or something gets stuck on evaluation, a notice will come in. There's no backup, there's no explanation, but it's put in as something, as a way of protecting one's rights, one's legal rights, as opposed to bringing people together to try and work out the problem. And that's where you start to see the contract being used as an attacking mechanism or as a defense mechanism, as opposed to a tool to be utilized to get through the project efficiently.
Yeah, some good points there, Rupa, thank you. So Tom, just moving on to you. So Mitesh and Rupa have highlighted some early warning signs around the dispute. But Tom, from your perspective, as the project progresses, what should people be doing to ensure that in the event of a claim or dispute, should it arise, that they are in the best position to either present or assess that claim before it gets too late? So Tom, any thoughts on that, please?
Good morning or good afternoon to all the attendees. Yeah, so I think on that point, Paul, from my experience, when we're involved looking at delay and quantum matters, whether that's for the contractor or the client, I think the biggest issue we face before we get to entangling the issues as such is getting sight of good contemporaneous records. I think there was a reluctance in the industry to keep those records for whatever reason. I think it's largely down to cost. Perhaps it's seen as limited use during the course of the project, but certainly, in our experience, it can make the difference between claims succeeding or failing. And we've seen that where parties don't have the records, they're relying solely on witnesses of fact, evidence, and they're weakened as a result of that. I think for me, it's about embedding that in the culture of the business, keeping it simple, but instilling from the top down that record keeping is a positive thing to do for that organisation. In my experience, where it's where you ask the right people on the project team to do that, whether that's the site engineers, graduates, and so forth, you often get a better trail of evidence kept. I think if you ask the project management team to do it, typically a firefighting on a daily basis, it's unlikely to succeed. Certainly from my perspective as a lay analyst, then what I like to see is really good photographic evidence in particular. Where that's kept, it's of huge importance to me in my role alongside the program data. But equally, don't just take photographs for the sake of it. Make sure they're annotated, make sure they are time dated and so forth. An example there is we work on multi-story buildings disputes in many cases, and you just get reams of photographs of piece of ductwork, bits of dry lining with no reference, no context to where that is. They've gone to great expense of keeping those photographic evidence, but not actually putting it in a presentable way for the delay expert or quantum expert at the end of the project to look at. I think beyond that, if you're working obviously for the employer side, then insist on the contractor presenting the records to you on a regular basis. Don't rely on the dispute arising when you first get sight of those records. I think it was in the contract from the start that on a regular basis they provide them to you. You've got a good audit trail then to assess any claim that may come from that. I think the other thing during the course of work is obviously notices. Rupa mentioned that. In my view, the giving notices should be seen in a positive light. It's there as a tool to recognise that something's about to come up that may be resolvable by the employer or the main contractor, should it be a subcontractor. So I don't think it should be seen in a negative light, but often that is the case. And equally, the other point I'd make is, and I think the bit that's often forgotten is the full particulars. If you look at the FIDIC, it calls for your full claim to be continually updated every 42 days on an ongoing basis. Well, how do you do that? During the course of the project, you need to do some sort of prospective form of analysis. You haven't got the benefit of hindsight at that stage of the project to do some sort of retrospective analysis. So you need to look at the best method to adopt. In that case, it's usually what we call a time impact analysis. It's a fair approach to both parties. It'll probably put you in the best position to get that assessed and agreed by the opposing side, that you've used the right methodology to start with. If all of that is in place, then at the end of the project, should someone like ourselves be involved, we've got a good body of factual evidence to use to support any kind of retrospective analysis should the dispute move on from there.
Excellent, thanks, Tom. And just in terms of, so just moving that on, you're actually in a dispute, or you're going into a dispute. What do you think should happen from the solicitors in terms of clear instructions? Have you got any advice that you want to just give to the audience here on that, please?
Who's that to, Paul?
Just Tom, just in terms of obviously just in terms of anything that you get from the instructions from solicitors. So from what I'm thinking here is reminding the solicitor if you're in a dispute or going into a dispute what your role is in terms of presenting the claim, and particularly if you've got your expert witness hat on. Have you got anything just to add on that, just in terms of putting some meat on the bones?
Yeah, I suppose it's be clear on the instructions. What are you engaging us to do? Is it to be the claims consultant, the advocate? Is it to be an expert advisor at an early stage where we're not there to present or draft the claims and so forth? And just be really clear of the exact input. And equally, in terms of the record keeping, get the client to give the information at an early stage. We could often get engaged, and it's a number of weeks before contemporaneous documents really flow through to us, and obviously that puts a time pressure on the whole process. So I think if the instruction solicitors are clear on what we need in terms of information sources, that's a great help at the early stages.
And you touched upon a point there, Tom, about obviously, are we an expert or are we an advocate? And I guess obviously, Mitesh, looking at it from your perspective, ultimately, you as the contractor potentially could be our client, so you pay our fees potentially, and that there's obviously some delicacy around that. But as Tom has alluded to there, we need to just keep the advocate role and the expert role quite separate, particularly if it's going to arbitration or litigation, which is obviously, it's got lots of minefields there we need to be mindful of. Thanks for that, Tom. David, just moving on down to you. So you've been sitting there comfortably and quietly, so thank you for being patient. So David, in the event that a dispute does arise, what do you think are the options for dispute resolution? And I'm thinking here particularly in jurisdictions such as India, where the litigation can be lengthy, and should they default to arbitration? And if not, what other options are out there, please?
Paul, thank you very much. It was very grateful to be invited to speak, and lovely to be able to listen to everyone already. It's actually how most advocates like to operate, although it's slightly chastening to realize when you were introducing Rupa that it's some years since I was introduced as being part of the next generation. But that's just a personal grief. Conceptually, every dispute, every contract has to have a final binding form of dispute resolution. Two forms that we have identified and that have effectively operate are litigation and arbitration. And sometimes people say, oh, I don't like the idea of having a dispute, so I just won't provide for anything. If you do that, all you've done is you've provided by default for litigation in any court that will take jurisdiction. So you must provide for a form of binding dispute resolution, and that's going to be arbitration or litigation. I wouldn't say that people should opt for arbitration in a jurisdiction like India. We are incredibly lucky in the United Kingdom, or in England and Wales really, that we've got the Technology and Construction Court, which is a specialist list with specialist rules and specialist judges. So in fact, in England, we can opt for litigation in the TCC, but in most other jurisdictions, you can't. And I think in most other jurisdictions, even if you're dealing with the Middle East or Australasia, the Far East, wherever, no party will want to be on the other party's home turf, either for reasons of culture, accessibility, language, whatever. So I think it's for very good reason that FIDIC uses arbitration as its default under the rules of the ICC, and other the norm for large international construction projects is arbitration as the form of final dispute resolution. So what other tools have we got? Well, there is one other final-ish form of dispute resolution, which is expert determination. Mm-hmm. Expert determination, people sometimes put in on the basis that it's cuddlier than arbitration or litigation. And that's actually a misconception. Expert determination is good for identifying facts that make the contract operate. People sometimes say, well, we'll have an expert determination for extensions of time, but you then get into questions of interpretation of the contract, allocation of risk, all that kind of thing. And you're dealing with those events, you're dealing with both time and money. So expert determination is much better for identifying a single fact that then, when inserted into the contract, operates. You see it in the oil and gas sector when parties are dealing with the continuing reserves of oil fields. Expert comes along and says the continuing reserves, the continuing reserve life of this is X, and you get on with that. So that's expert determination. Turning then to the other forms of dispute resolution we have, those people in the audience who are familiar with practice in England and Wales or the United Kingdom will in fact obviously be used to adjudication, statutory adjudication, and then what we've done to develop that in the last 25 years in the UK as a form of quick initial dispute resolution method that can work in large international projects. I think what's better in large international projects, and this goes to what Mitesh was saying and what Rupa was saying about not letting a dispute develop and taking a dispute offline, is the idea of dispute review boards, as you see in large projects. Now, unfortunately, people provide for dispute review boards and then forget to constitute them. And I've done as many disputes that have not gone through the dispute review board that should have been there, as have gone through the dispute board that was there. These are not like adjudication. This isn't like a standing body of adjudicators. Sometimes they're set up like that. So you just have effectively adjudicators who are on tap when you want them. Really effective dispute review boards, and a very good example, I think, is the one that was set up, as I understand, for the new Forth Crossing up in Scotland. The review board will go to site every month, every 2 months, every 3 months, depending on the project. And we'll sit down with all the parties for a day and say, well, what's happening? It's exactly the sort of idea that Mitesh was talking about and then Rupa was talking about in terms of notices coming through. Well, is the program on time? The program isn't on time. Oh, what's slipping? This package is slipping. Okay, any problems there yet? No problems there. They come back in 2 months' time, 3 months' time. That package is now significantly slipped and is now onto the critical path. And they can then help people resolve that kind of issue. I think dispute review boards on large international projects are wonderful. The other thing that I think is people see that is effective is some form of senior management discussion and mediation. And this goes back to Mitesh's observation that I think is very true. Disputes arise at sort of middle management level, with greatest of apologies to anyone who might either be dealing with the dispute at the moment or be in middle management, but that is where disputes arise. You need to be able to elevate a dispute, as Mitesh says, to a sufficiently senior level that people can say, look, let's take a wider picture, either of this project or of our overall commercial relationship, or of just how much we can get this away for and settle things, which generally can't happen at that middle management level. Now, people sometimes write dispute resolution clauses. And if you go from middle management, if the senior managers can't resolve the dispute, then you go to a more formal negotiation with mediation. People sometimes say, that's a great idea. We will mandate middle management, senior management discussions and mediation before you can ever go to arbitration. And in my own view, that is a dangerous and difficult thing to do. And the reason for that is that I have done a number, and they've given me nice work, and it's interesting work, and it's well paid. of disputes where the senior management discussions don't resolve the dispute. The mediation doesn't resolve the dispute because one or other party has just entrenched or has cash flow problems. You then get to the arbitration and you're in the arbitration and you then have problems with a challenge to jurisdiction, which gets very technical from Rupa's perspective and my perspective, saying, no, you can't even start this arbitration because you failed properly to conduct the senior management discussions, or you failed properly to discuss the mediation. And you end up with completely wasteful satellite litigation because one party wants to obstruct. And I did one case where there was an escalating dispute resolution provision, which led to 3 lengthy hearings in front of the tribunal and 2 outings in front of the English Commercial Court, just to determine whether that provision had gone through. They're a great idea to write in and legislate for, because it means that one party can say, this is a good idea, let's do this. We're supposed to talk, we're supposed to mediate. But mandating it, I think there are issues with that.
Super. Thank you very much for that, David. There's a couple of things just to come back on you on that. We're representing a number of clients at the moment where we're seeing that expert determination is the chosen dispute resolution of choice. That's an interesting proposition there that you've put in terms of the expert determiners is an alternative route of dispute resolution, and we are seeing that. How effective it is, that's to be seen in terms of what the award will flow from that in the disputes that we're currently representing the parties on. The other thing is, and it's a very valid one, about the DAB. So again, I'm working for an international client at the moment, and they're falling out with the engineer around delay and cost, and they are citing the potential to go to arbitration. And I've referred them back to the DAB under the contract, and they just forgot it existed, and that they'd signed up to it. And that's a lot more slicker process than the arbitration that they were wishing to go down. So who knows where that would end up. But yeah, some valid points there, David. So thank you very much indeed for your knowledge there. Rupa, just coming back to you, if you don't mind. At what point should people start to prepare their team for the dispute resolution process? Should they wait until everything is needed? Or are there, in your view, financial benefits in bringing in advisors early? And if so, who needs to be involved and at what stage? And David, if you want to bring in any input to that, that would be also useful. So Rupa, over to you, please.
Thanks. I think it's a loaded question when you talk about financial benefits of bringing lawyers in and at which stage, because it sounds like I'm going to give a really self-serving answer. But, the reality is, in a very short answer is you need to get your advisors in early. And actually, David, you've touched on it, the dispute resolution advice needs to come in from your advisors pre-contract stage, and making sure that when you're drafting your contract, you're agreeing your contract, you've got your advisors in to ensure that you've got a proper dispute resolution mechanism. So, it's as early as that. And there are different points at which your role evolves as an advisor. So when you have the early warning signs and the troubleshooting, your advisors should be assisting you at that stage. So not using a sledgehammer to crack a nut, but they should be working with you throughout the life cycle of the project, so that if there are bumps along the road, they can help to manage those out. Because what no team wants is, from your expert's point of view, from your lawyer's point of view, from your own point of view, is to have a team rushing together when that panic has set in, when the project is out of control, the records are not there, and then you're trying to piece it together. It's just not going to work. It's very expensive, it's very difficult, and you are taking valuable resource away from what will be a critical point in the project. If you have early input from the outset, who are, with your team advising you, with your infrastructure set out right, it means that it's helping to wheedle out those problems on the project which don't need to escalate to a full dispute resolution, because that's what you want to do. We all know from working on construction projects that there are going to be problems. It doesn't matter which jurisdiction you're in, that's just the nature of the beast. And there are a percentage of those problems which don't have to escalate to a full dispute. They can be managed and done away with. But equally, and I'm just dealing with something like this at the moment, formal dispute resolution is absolutely necessary and it's appropriate. And it's being able to distinguish which of the problems fall into which pot, which ones can be dealt with by senior management or by some sort of negotiation, and actually which are the ones that you really need to think, right, we need to go all the way on this. And if you have your team, your experts, your lawyers, if they're working with you throughout the project, so it's not 100% of the resource all the time, but it's managing that process, you will be able to ensure that you're dealing with matters as they come along in a proportionate way. So your spend, there's value in your spend, and you're not having to deal with lots of legal costs or experts costs, because you'll have done away with those problems when you can. So the ones that are out of control, where you need that further input, you need to go to arbitration, you need to go to litigation, you've managed it accordingly. So as early as possible, I would have thought, but little and often, and then the ones you can't get away from, that's where you bring in your full team.
Thanks, Rupa. David, anything to add to that from your perspective, from the QC's eyes?
Yes, I mean, I think obviously a construction contract that had a silk brought in at its inception would be an astonishingly pessimistic view and approach to it. So it really is working with the, in terms of the legal team, people like Rupa who put the contract together and the project together, and talking to the person who's put the project together as it goes on to discuss issues. I think that a team that has, for example, a programmer on it like Tom is invaluable, because having someone watching the programming as it develops, redoing the program, which the contract requires. As Rupa said earlier on, these things that look like they're part of the dispute resolution process are also part of making the contract a tool to deliver a contract effectively. And so having a programmer on the contract all the time looking at matters makes matters better from my perspective. Rupa mentioned notices, and making sure, again, notices work in two different ways. They are either a tool for making the project work, because it's somebody putting up a flag and going, look, we've got a problem. Or by the time it gets to me, notices need to have been served, otherwise rights may be difficult. And it is far easier for me to say, here's an event, here's the notice, here's the relief that we seek, rather than have me spend a day trying to think of some dreamy way around the fact that a notice hasn't really properly been served, or sitting down with Rupa and saying, well, what can we construe as a notice? So from my perspective, when I come in, if there has been a programmer involved, notices involved, active contract management by the owner or by the contractor, it means that my job becomes much more straightforward. And then the final point I'd make about programmers and experts generally, but this is particularly with programmers, is sometimes it's worth having two of them. It is very difficult when somebody hasn't had enough programming input and a project is late. When the client goes to a programmer and says, right, tell us what's happened, and the programmer then has to put everything together and explain why the project is late. And then you turn around to the individual like Tom or to you, Paul, and say, congratulations, you're now our expert witness. It is far better, far easier if the internal discussions are done with one programmer, everything is worked out. They're sometimes referred to as dirty experts. And you then have a clean expert who you go to and say, this is the package in relation to programming. Can you please have a look at it? You may not agree with everything. Tell us what you agree with. Tell us what you disagree with. And you'll be our expert. And that, I think, actually, that sort of double teaming when it comes to expert advice and expert evidence can be really valuable on large projects.
Yeah, absolutely. I would concur with that statement, David. And just some observations from my perspective. I think the due diligence, as I call it, whereby the contractors on the large projects can actually afford to have somebody to go in to check, carry out some checks and balances on the program, the analysis, the updates, the notifications. That is invaluable because, as has been alluded to already, once the horse has bolted, it's sometimes too late to make sure the evidence is there, make sure the notices are there, make sure the program is being properly updated, as opposed to just being, as I call it, fudged and giving it an incorrect position. So I think there's some merit in some of that due diligence work. But Mitesh, just coming back to you just slightly on that, and I guess it's balancing the bottom line, in terms of you have a project team, that project team are competent to deliver that project. But at what point, from looking at it from the eyes of a construction company who's got to earn money for its shareholders at the end of the day, as well as delivering a project, is there merit from your perspective of bringing in that due diligence support?
I think the answer is definitely for us, because the larger projects, it's too much work in a really short period of time if you have to try and retrospectively build a delay analysis program. So taking on board what David said, we're engaging that through our larger projects where we have a full-time programmer, an external programmer supplementing our internal programmer, and it's monitored. As quite rightly David said, we need to do that anyway for the contract, but it's also very useful if we have to demonstrate why we're in delay or reasons of changes to the critical path. So we advocate that for our larger projects because it's little and often due diligence all the way through. And if there's a problem, it's easy to demonstrate, but also if there's a problem, we're ready to, quickly put processes in play to resolve it using the delay analysis and the programmers.
Super, thanks, Mitesh. I am conscious of the time, but I have got some other questions that I'd just like to run through, if that's okay with the panelists and the attendees. And we have got one, I think we've got one question, or one observation, should I say, in the chat. And I also think that Andy Hewitt would like to make a comment. So I must leave time for Andy to say something before we run out of time. But just sticking with yourself, David and Rupa again, construction disputes, they are different to other disputes. But so briefly, why do they require early engagement from advisors and other disputes? In your view, why do construction disputes differ to other disputes, please? I'll bring that one to you, Rupa.
Sure. My experience, is centered around construction disputes, so I can only speak to what I know. But the reality is that construction disputes, and right at the outset, I talked about having that essential interface between your legal team and the technical team. I think that is something that is very particular to construction projects, and that comes through right from dealing with the project to the disputes. When I'm advising on a delay claim and when we're looking to put a delay claim together, I have to work really closely with Tom, because whilst I can give a view onto what the risks are in relation to delay under the contract, I am so heavily reliant on what Tom will need to tell me in terms of what actually happened on the project in order to give an overall opinion to the client, whether it's acting for the contractor or acting for the employer, as to what the position is. And, translate that into a defects claim. If I'm advising a client who's come to me because there's a problem with the bridge, I can look at what the contract is and see who has responsibility for design, who has responsibility for the bid. But in terms of understanding whether or not there is a claim for negligence, I need the technical expert to tell me whether or not the calculations for the loadings that were put on the bridge are absolutely right. I certainly wouldn't rely on me doing that work. But that's the thing. And actually, when you look at the span of construction disputes, trying to work out whether glass on this skyscraper in London has been toughened using the right processes, what the relevant standards are, what standards were in play, what was actually done, and how then that feeds into the legal analysis. The technical input and the legal input and working together is absolutely fundamental. And that, I think, is something that is very particular to construction disputes. And you're equally reliant on both getting that job right and getting that job done where they can work really well together. It needs to be a seamless operation between your legal and your technical team. And without that happening properly, I think by the time you go to leading counsel, I don't think David can do his job properly unless we've got that interface between us and that work, that preparation has been done literally like this. And that, I think, is something that is very particular to construction disputes. So you need to work, I need to work very well with my expert. He or she needs to be somebody that can explain something very patiently. So at the end of the case, I can tell you all about structural loadings, and having that dynamic, I think, is very, very important.
Super, thanks, Rupa. In the last few seconds, there's been a myriad of questions coming into the Q&A and into the chat, which is great. Some of them I think we've already picked up already. Tom, just one for you before we go on to those Q&A, and hopefully this will tackle some of the questions in the Q&A. In terms of bringing value to the dispute, and how do you manage the important difference between being an advocate and an advisor and being an impartial expert? So any comments there, Tom, that you want to come back on, please?
The point there is, as David said, it's probably a split role in terms of advocate and independent tribunal expert. I think, can you honestly present your work as independent if you've been involved in drafting the claims at an early stage? My view is not. So I think, as an expert, you've got to be clear on what instructions are. Don't stray from those instructions. Consider what the rules of the tribunal are. I mean, if you look at the IBA rules, you need to sign a statement of your involvement with the past and present with the relationship of the parties, and equally a statement of independence. If you've been involved in drafting the claims and so forth, you're going to struggle to honestly sign up to that. So I think, as David said, it's two roles in certainly the larger disputes, where you have a planner, a lay expert involved early, drafting the claim submissions, then an independent expert that tests the main issues and so forth in the tribunal. I think that's probably the way to deal with it. I don't know, David, whether you've seen experts come and stuck where they've had early involvement with at the claim stage as it proceeds to trial or not.
Yes, I mean, it's not only seen experts come unstuck, I've made experts come unstuck. Because where an expert has been involved at the very beginning, there are times when you can see their fingerprints in the way in which the claim has been formulated, and then in their expert report. And you can, if you track it right back, that it's their theory that's being run, then you can tie them to that theory, and that's when they run into problems. When I sit as an arbitrator, I actually say, when I sit as an arbitrator, I want advocates and experts to help me write my award. Not literally, but that's what I've got to do. I've got to sit down when everyone else goes home. I've got to sit down and write my award. And so if there's some bit of technical expert, as Rupa, technical expertise, as Rupa says, or programming or whatever, and I sit there, I sit with a sort of blank sheet of paper in front of me, and I think, I still don't actually get the issue about loading. Where is it? What? That doesn't help me. The expert who sort of sits there and explains to me and teaches me, educates me as a tribunal, or when I'm advocate, who teaches me to the point where I can stand up and say, this is the answer. Those are the experts who I remember and I like. And I think people should remember, and this is why I like witness conferencing. If you take two experts and they're doing their job properly and they're both properly qualified, those two experts should agree on, I think, 90 to 95% of everything they discuss. It's the last 5% that make them go in opposite directions on their conclusions. So the expert who just digs in, runs a theory, disagrees with everything his opponent says, doesn't help me at all, and is actually quite vulnerable on cross-examination. The expert who says, I'll tell you all the 95%, I'll help you identify the last 5% and why it affects the answer. That's the expert who I really like.
Thank you, David. That's really good advice. Mitesh, just one final one for you, because I am conscious that we have overrun slightly, but I'm sure that there's some attendees here today that would like to have some of your knowledge about how you manage and engage with different types of advisors when you resolve disputes, if and when you get into them. So what advice could you give to others in that regard, please?
So, Paul, I'm a contractor, so the litigation for me is just like another construction project, but albeit a very complex one, you know, where you've got finite resources, people and time, and a mission. So, you know, all of that in one pot. Yes, in terms of picking the right advisors, I would say, you know, we speak to industry peers, advisors like yourselves, to sort of suggest the right team composition, putting together the expert witnesses early enough, getting their advice. And in terms of managing, it's a full-on activity, and that's why it's spend the energy trying to avoid those disputes with spending the little and often due diligence that we've been talking about earlier, and the pre-contract stuff that we talked about earlier, because then you can avoid that. But if you're in it, in terms of how to manage it, it's literally, you know, it takes a whole resource out of your business in trying to manage that team, and making sure that the chemistry, the dynamics with the team is also, you know, have they worked before together, and, you know, what's the chemistry between different members of the team in terms of putting together, because it's all very short deadlines for turning responses back, and putting together the technical piece as well with the legal piece. So it's very resourcing and requires a lot of management with the clients in terms of the sort of the lead legal consultant, making sure that everyone's doing what they've got to do. So that aspect is very much running another project within the project. It's full on.
Super. Thanks, Mitesh. So that brings me to the end of the panel questions that I wanted to ask today. We have got some questions in the Q&A, and as I say, some of them we've already answered in terms of the conflict between the expert advice, expert evidence, and the advocate. There's one in here with regards to cladding issues and who we think is responsible, but I don't think that is one for this audience today. So I'm not going to put anybody to answer that question. Well, there is one here regarding the what if the contractor goes insolvent, and how can clients' interests be safeguarded with regards to insurance and performance bond. But I guess it goes the other way. What if the client goes insolvent, and how can the contractor protect themselves and ensure they get paid? So has anybody got any views on that? So I'm just thinking here, Mitesh, from your perspective, what would you say about insolvency? And then similarly, Rupa, from the legal perspective, have you got anything to say in that regard, please? So over to you first, Mitesh, please.
So I think for us, it's all about the due diligence at the early stages of getting into contract with a client. And if there's SPV involved, what safeguarding measures can we put in place? Can we put bank guarantees in place, personal guarantees? There's all sorts of measures that you can put in place, escrows. We tend to look at our legal team to help us with that once we've identified a potential risk. But we're in the commercial world, so you can try and ring fence stuff. Eventually, you know, if you've had a run of bad luck, you're going to hit a brick wall, and something's going to happen. So there are measures. We do take those steps, but it's also a tricky balancing act to make sure that you don't want to be over belt and braces that the client walks away from you, or it just doesn't make commercial sense for them.
Sure, thanks, Mitesh. Rupa, anything to add to that, please?
Yeah, I mean, I think Mitesh has hit the nail on the head in terms of the diligence that you do at the outset, and then putting in certain mechanisms within your contract, or with terms of bonds, or guarantees, or escrows, but or vesting clauses in terms of materials. But I think also being alive to signs that things are starting to go wrong again in the project. So if there's silence from a particular subcontractor, or you see a level of resource dropping, there are warning signs that you can pay attention to as well, which means that those safeguards that you put in at the outset, again, that needs to be mitigated. It comes back to being on the ball during the course of the project. So having mechanisms put in at the outset to mitigate that risk, but then ensuring that you're looking out for those early warning signs, you know, step-in provisions as well. So all of those can be utilised, but it really needs to be managed actively through the project.
Super, thank you, Rupa. I am conscious of the time, and it's nearly 9:30. So I know that Andy Hewitt wants to come in, but there is just one observation here with regards to expert determination, and we have an attendee that recently made an award, expert determination of $3 million US dollars, it would appear, in less than 3 weeks. So in that regard, it seems that expert determination was successful. And the statement here is everyone stayed amicable, and the expert determiner in this instance takes no credit that he says. So that's good. That's good to know. Annie, I think Andy Hewitt was wanting to come in. Is he there? Do you know?
He is, in fact, and hopefully you can hear me. I'm sorry I couldn't take part, but my connection here is so unstable. I've managed to hear most of what everyone said, and I want to thank all the panelists for taking part today. It's been a really, really interesting discussion. And I would like to focus on the fact that we've got, as well as Mitesh, contractor, we've got ourselves who assist both employers and contractors, Rupa and David, who are lawyers that are heavily involved in disputes. But I'd like to sort of focus and thank everybody for putting their own focus on the fact that the best way to deal with disputes is not to have them in the first place, and not to have to engage expensive people like experts, lawyers, QCs, arbitrators, etc., etc. So I'd just like to highlight what experts in the industry, such as HKA, Arcadis, and FIDIC, have identified as the leading causes of disputes. And if we go back to these reports that very well-established organizations have reported, and a couple of the biggest reasons for disputes occurring are failure to administer the contract, which we've talked about, failure of the parties to perform their obligations, which we've talked about, and one which we see an awful lot are inadequately expressed claims, and sometimes inadequately expressed responses to claims. So what we're saying here is that the contractor has entitlement or doesn't, but the way that the contractor deals with asking for his entitlement, or the way that the employer and his consultants respond to that claim, is just badly put together. And the reason that we see all the time is that the teams that are managing the project, either through the consultants, the employer, or particularly the contractors, are not adequately qualified, are not adequately experienced, and this leads us down to these reasons for disputes. And when we look a little bit further, contractors, maybe Mitesh doesn't fall into this category because he's learned from experience. The real reason is we want to save money. So when we're putting the tender documents, the contract documents together, we are amending standard forms of contracts such as FIDIC. Instead of going to somebody who knows what they're doing, we give it to a guy that knows a little bit about it. And then thereby hangs a problem, because when we get conflicts and ambiguities in contracts, we're starting off on the wrong foot right from the very, very beginning. So time, money, and effort, as Rupa mentioned earlier, is well worth spent right at the beginning, before the job even goes out to tender, before we've entered into our contract. We then move on to the execution stage. Contractor doesn't want to spend a lot of money on his team, on his resources. So unfortunately, he doesn't have adequately qualified, experienced people on the team and thinks he can just manage. And it doesn't work, because if he's not managing things correctly, he's not sending his notices in, he's sending notices that are meaningless, he's not putting his claims together in a way, and David came back to this again. If you don't explain in your claim why you're entitled and to how much you're entitled, we then are heading towards a conflict. So whether you want to, people like David, spend a lot of money on having an expert on your project, and if it's going to be one of those amicable projects, well, probably not. But at least have someone on hand that you can refer to, that you can bring in when you see a project heading this way. And typically, the sort of work that we get involved with, the project's going along, the contractor's not handling things very well. We get to the end of the project, we're losing money, we need an extension of time, we've got delay penalties pending, and all of a sudden, in 80% of the contract periods disappeared, and we now start thinking about potential claims, disputes arrive. That is absolutely the wrong time to start dealing with disputes, with claims, with contentions. A small amount of money spent in the early stages will prevent a lot of money being spent in the later stages. So it really is false economy. So I'm going to come back down to my message for today is the best way of dealing with disputes is to not to have them in the first place.
Thanks, Andy. And I'm glad your internet just held out there. So thank you very much for that feedback. So that brings us to the end of the session, the webinar. I am aware that it's going to be online in a few days' time. I would like to thank the attendees for joining. I'd also like to thank the panelists for their knowledge and input. These things don't happen overnight. It's a tremendous amount of time to prepare for them. I'd also like to thank the panelists for me not having to say you are on mute. I think that's the first time I've done a webinar where that hasn't had to be said, so well done. And I'd also like to thank Stuart and Annie from Limeslade for facilitating the event and helping us to run it today. I wish you all the very best of health. Take care and look forward to seeing you again soon. Thank you very much. Bye-bye for now.
Thank you.